Welcome everyone, I'm Dijen Basu. To my left is David Lawson, to my right Elliot Gold. We're barristers practicing from Serjeants Inn Chambers. Welcome to this recording that we've made on the coronavirus emergency and the police powers associated with that. It's worth acknowledging the enormity of that phrase, coronavirus emergency. A century ago, after the devastating Spanish flu pandemic outbreak, Parliament passed the Emergency Powers Act 1920, enabling the King to make a proclamation of emergency. Such proclamations were made on 12 occasions, the last being in 1974. But none of them was in reaction to war, terrorism, flood, famine or disease. In each case, it was in order to deal with strike action. The Emergency Powers Act was repealed by the Civil Contingencies Act 2004 in the wake of 9/11. And as a result, we no longer have any such thing as a proclamation or a state of emergency in the laws of the United Kingdom. But make no mistake, we are in a state of emergency. I'll now turn to the Coronavirus Act 2020, which will be in force, we anticipate, from Monday the 23rd of March 2020. And the important schedules in relation to the police are Schedules 20 and 21. Schedule 20 deals with potentially infected persons, 21 deals with gatherings. Those are the main sources of law in that act that will affect the police. Let's start with Schedule 20, potentially infected persons. First of all, the Secretary of State can designate an area of the world as an infected area, and that's then published online, and as soon as practicable, it's published in the London Gazette. And the significance of that will become relevant later. Paragraph 4 of that schedule enables the Secretary of State to make a declaration that the transmission of coronavirus constitutes a serious and imminent threat to public health in England, and that the powers in Part 2 of the schedule will be an effective means of delaying transmission and preventing it. Now, such a direct declaration has already been made in connection with the Health Protection Coronavirus Regulations 2020, and those regulations will be revoked by this Act, and that declaration will then carry over and be effective as if it were a declaration under paragraph 4 of Schedule 20. I should also say there are virtually identical provisions made in relation to Northern Ireland, Scotland and Wales, where rather than the Secretary of State, it's the relevant ministers or the Department of Health in the case of Northern Ireland who make the relevant declarations. So on Monday the 23rd, Schedule 20 will be in force because there will have been a declaration made, it will be effective. Schedule 20 gives powers to public health officers to request, not instruct, but to request a police officer, a constable, to remove a person to a place for screening and assessment. And such a constable can use reasonable force, if necessary, to do so. Schedule 20 also enables a constable separately, if he has reasonable grounds to suspect that a person is potentially infectious, to direct a person to go to a place that's suitable for screening or assessment, or to remove the person to such a place, and again, using reasonable force. Now, the police will have to have regard to any relevant guidance issued by the Secretary of State, and that guidance may, when published, specify what is a place suitable for screening or assessment, or such places may be designated or recommended by public health officers. I'll come back to that in a moment. But the first question is, what amounts to a person who is potentially infectious? Well, there are two alternative limbs. The first limb is this, that the person is or may be infected or contaminated with coronavirus, and there is a risk that the person might infect or contaminate others with coronavirus. Now, we think contaminated is likely to mean exposed to, but we think officers should proceed with care in relation to the issue of contamination. We'll explain that in a moment. Now, the second limb by which a person can be suspected to be potentially infectious is if they are reasonably suspected to have been in an area declared to be an infected area within the preceding 14 days. And that's the relevance of those declarations of areas of the world that are infected areas. Now, guidance may shed light on all of this, One difficulty we envisage is that infection or contamination is a medical and not a factual question. So it may be necessary to give police officers training on what observable symptoms would constitute reasonable grounds to suspect that a person is or may be infected or contaminated and may infect or contaminate others. Now, what amounts to reasonable grounds to suspect that a person is potentially infectious? Well, there must be some objective grounds for the suspicion based on the known facts, which would be sufficient to satisfy an objective observer that the person was potentially, or may be potentially infectious. Now, we consider that the most common reason for suspicion on the part of a constable that somebody is potentially infectious will be a report from a medical professional who's able to give an account to the officer of that person and why they're potentially infectious. Now, the power, it's important to note, is only exercisable if it's necessary and proportionate to exercise it for the interests of the person, the protection of others, or the maintenance of public health. And again, that issue may be potentially informed by a doctor who's making a report to police about a particular individual. And secondly, it's important to note that the officer must, before exercising the powers conferred by this paragraph, i.e. the paragraph I've just described, consult a public health officer to the extent that it's practicable to do so. And you can see the good sense of that, because that consultation may well inform the officer as to precautions to be taken by the officer and others in relation to the individual, and also in relation to what place to take the individual to for screening or assessment. If the person exercises this power in common with powers of arrest, which this is not, but in common with powers of arrest, certain information must be given. So the officer must inform the person in question of the reasons for directing or removing them, and must inform them that it is an offence where directed to fail to comply with the direction without reasonable excuse, or where removed to abscond. Now, Schedule 20, when it's enforced in a transmission control period, enables a public health official, a public health officer, to require a person to remain at the place for screening for up to 48 hours. And an ancillary power that an officer may have, will have, is to keep the person there if necessary, and may detain them for that purpose. And the constable can keep them at the screening place so that the public health officer can exercise his functions for up to 24 hours, extendable by a superintendent for a further 24 hours. Now, out of an abundance of caution, we would say that it's important to note that if the superintendent in question is an acting superintendent, the direction to act up must be a genuine one, must not just be a one-off short-term direction simply for the purposes of purporting to take this decision. After the screening, a public health officer can order a person to remain at the place or remain in isolation from others for periods of up to 14 days, and he or she can restrict their travel or movement. And in association with that power, a constable can remove the person to the place specified, or keep them there, or take them into custody if they abscond. It's an offence for people to fail to comply with the orders made by a public health officer in relation to this paragraph, and therefore that can be enforced if necessary and appropriate by arrest and charge. We consider arrest may be necessary in some cases to prevent physical injury either to the person or to others. That will of course be a matter for the officer to be satisfied they have reasonable grounds to believe. The individual in question has a right of appeal to the magistrate's court, and in any event, any restriction has to be regularly reviewed by the public health officer, and it can be reimposed and then further reviewed. And those restrictions come to an end if the transmission control period comes to an end by revocation of the original declaration. Now, officers have general powers in the exercise of these powers I've just described. And their general powers include both the use of reasonable force for the exercise of any power under Schedule 20, and also the power to enter any premises. And I'll come back to that in a moment. In the course of exercising their powers in this schedule, police officers can give reasonable instructions in connection with giving a direction or removing a person or keeping a person at a place. And it's an offence for an individual to fail to comply with such an instruction without reasonable excuse. So lastly on this schedule, what if the constable exercises their power to enter a place for the purposes of exercising their powers under this schedule, and they find that it's a den of iniquity, drugs in the corner, proceeds of crime, stolen goods, etc. Well, of course, if it is necessary or appropriate to investigate those other offences, and officers may think it's better just to leave that to another day, but if it is necessary, they will of course remember to arrest for the offences disclosed, if that's necessary, and then to use their Section 32 powers or Section 18 powers to search the premises in question. Let me turn now to Schedule 21. Now, this schedule requires a similar declaration by the Secretary of State, and that's for the purpose of preventing, etc., the spread of the coronavirus, or for the purpose of facilitating the most appropriate deployment of medical or emergency personnel. Of course, emergency personnel include the police. No declaration has yet been made because this is a new power, and so it's not being held over from the coronavirus regulations I described earlier. We anticipate such a declaration may be made very soon, if not almost immediately after the coming into force of the Coronavirus Act. When such a declaration is made, it starts off something that's been described as the public health response period. Now, during this response period, the Secretary of State, or of course in the other nations of the country, the relevant ministers or the relevant department, can issue a direction prohibiting or imposing requirements on the holding of events or gatherings. And those events and gatherings can be described generically or specifically. And importantly, such a direction binds the organisers, etc., organisers and managers of the event, but not those who are merely attending the event. So it's important to note that, because where people attend an event that's been held in breach of such a prohibition, perhaps in very large numbers, the police will have no powers under this schedule to disperse those attending. It's very important for officers to recall that. The Secretary of State can also impose requirements prohibiting or imposing conditions, etc., on entry to or departure from, or the location of persons within premises. And premises include any building, structure, vehicle, aeroplane, or even tent or caravan. And those premises can be specifically or generically described. And an example would of course be restaurants and bars that have been hitherto relatively well attended and crowded, and in order to enforce the social distancing that's been recommended by Public Health England, it may be the Secretary of State imposes conditions on entry to, departure from, and location within premises as widely defined, so as to enforce social distancing, as we've seen in countries like Italy and in France. Now again, such a requirement binds the owner or occupier or other person involved in managing entry or departure or location within the premises, but it does not bind a mere attender at those premises. So again, officers can't go in and exercise any power, any coercion against the mere attenders or arrest anybody, but they can exercise potentially powers of arrest against the owner or occupier. But bear in mind that the offence that's created in relation to this of failing to comply with such requirements is only a fine, and so it may be disproportionate to arrest organisers for less serious infractions but it might be proportionate and necessary to arrest them for very serious infractions of directions or requirements or orders made under this schedule.